This week on the American Law Journal, two cases before the U.S. Supreme Court. One slanted in the direction of trademark, the other dressed up for copyright protection. Both will tell us a lot about the bounds of commercial free speech. Gina Passarella has this.
Sorry if I know it's too sharp. Sorry if our voice is too raw. Don't make the pen a weapon and censor our intelligence until it costs me nothing at all.
How did the slants
Sorry if you take offense.
wind up on the steps of the Supreme Court? Because the government denied a trademark for their name under a law known as the Lanham Act.
It allows the Patent and Trademark Office to prevent registration of immoral, scandalous, disparaging marks, and it also has provisions for marks that might deceive the public. And in this particular case, they made the judgment that the slants, the name of a particular band, was disparaging of Asian people.
But for Simon Tam, bass player and spokesperson for the slants, it's always been about reappropriation, taking a slur about Asian Americans and reclaiming it as their own with cultural pride.
Whenever you Googled slant or slants, the top hits all on Google for the first 4 pages were all to white supremacist websites. And now it's to a rock and roll band that proudly shares its heritage, and I think that is super cool.
And now it's up to the nation's highest court. And although the slants case looks promising, there are no guarantees. The government wants to prevent registration of the most vile racial epithets and messages, and to disassociate itself from speech it finds odious. Case in point, the intellectual property highway is littered with thousands of so-called disparaging names denied trademark protection.
That's one of the arguments of the Trademark Office, is that we're not preventing you from using the slants or redskins. You can still do that. You just can't register it with the United States Patent and Trademark Office.
But getting a registered trademark is a highly valuable business asset, a notion often lost on young members of rock bands. Roger Stevens, founding member of Blind Melon and an attorney with the Ballard Spahr law firm, provides a cautionary tale from his early days with the band.
In rural Mississippi, not too many people are trademarking stuff, so it never came up. But I would advise people to think about it early on, because by the time we really got down to dealing with it, we had already started selling records and money was coming in and nobody knew what to do about it. We had some imagery that was the B-girl, for example. It was popular and somebody was making money off of it. We had not trademarked that image or the name from what I understand, until later.
The slants now hope their betting everything on the First Amendment argument will get them their trademark. And they aren't the only ones betting on the outcome.
Cousins to the middle of the field, complete, and that is a Redskin touchdown shot.
The Washington Redskins, whose canceled trademark is tied up in the courts, believe their rights will be restored if the slants prevail.
So I think these are old provisions of the Lanham Act that are archaic, out of date, and should be thrown out completely.
If the government truly cared about fighting racist messages, they would have canceled the registrations for numerous white supremacist groups before they even approached our case.
By granting the slants a forum, the U.S. Supreme Court is putting the First Amendment and the U.S. government's right to restrict trademarks in the spotlight, raising the question of whether the government is up to the task of deciding what is disparaging or immoral. For the American Law Journal, I'm Gina Passarella.
Technology's improved so much that now political parties and political analysts can get down to such a granular level that they can pick and choose their voters all the way down to households, individual households, to ensure that they can keep their incumbency in their position.
Let's take a look at George Beatty's district. That, again, he ran in 2012. And George, here's what your district looked like in 2002. That looks pretty compact and contiguous. Here's what it looks like in 2012. The Washington Post, again, called this goofy kicking Daffy Duck. I actually think it looks more like the Energizer Bunny. But that's what you had to fight against.
It's simply outrageous, and it's bad for democracy. It's bad for our nation, whether you're on the Republican side or the Democratic side. It forces the candidates to an extreme. So if it's a safer Republican district, it forces that Republican to go far to the right because he or she is more afraid of a challenge from the base than from the other party. Conversely, with the Democratic side, the same thing.
Why should we be confident, even with a Democrat and Republican sitting down together, that true change is going to take place here? What's it going to take to convince this state like many other states across the union, that it's time to get rid of state legislators drawing our maps, usually from one party, and get an independent commission in there instead?
Well, you're right. We can't hope to take the politics out of this process unless we take the politicians out of the redistricting process. And the thing is, I'm confident that we can make this change if the public is engaged and understands why this is so important. I mean, our redistricting process is the very foundation of competitive elections, a competitive legislature, and how competitive a legislature is going to be. It's the very rock, it's the foundation of a representative democracy. And I don't think the public truly understands what's at stake here. And as these programs educate individuals, I believe that the voters will rise up and demand this change.